Good morning on the West Coast and good afternoon on the East Coast. My name is Jamie Hawk. I'm a lawyer with the ACLU of Washington and a co-chair of the Civil Rights and Social Justice Section's Civil Rights and Equal Opportunity Committee. I will be the moderator for today's discussion. We are thrilled to be presenting this timely webinar entitled Restoration of Voting Rights, the Elimination of Felony Disenfranchisement, sponsored by the ABA section of Civil Rights and Social Justice. This panel is one of many in a series commemorating Black History Month. We are actively planning additional programming on a variety of issues, so please visit the website for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. It makes it much easier to track and respond to questions in the Q&A. We will address questions at the end of the panel, and we will be sharing a recording of this panel to everyone who is registered so that you can share it widely with your networks. And so with that, we're thrilled to bring you today's program. There are 3 members of the panel. You will hear from them for several minutes each about their perspectives and expertise on the issues being discussed today. Then I will ask the panel a few questions and we'll open up for discussion and questions from the audience. For purposes of initial introductions, I'm pleased to welcome our esteemed panel. I will provide a brief bio of each panelist before they speak for the first time. Our panelists today are Nicole Porter with the Sentencing Project, Eliza Swerin Becker with the Brennan Center for Justice, and James Jetter with the Yale Prison Education Initiative. Welcome and thank you all. To briefly frame our discussion today, I want to just share a couple quick comments. The right to vote is one of the most basic fundamental rights guaranteed to citizens of the United States. Although the 15th Amendment provides that the right to vote shall not be denied or abridged on account of race, 48 states have felony disenfranchisement laws which disproportionately impact African Americans. These laws are an example of structural racism. Today, we will discuss the growing momentum to dismantle felony disenfranchisement and restore voting rights across the country, and why it is a racial justice and voter suppression issue. In August of last year, the ABA adopted strong policy urging federal and state governments to repeal laws that disenfranchise persons based upon a criminal conviction, to restore voting rights to those currently and formerly incarcerated, including those on probation, parole, and any other community-based correctional program, and to ensure that no person convicted of an offense is disenfranchised because of non-payment of a fine, court costs, restitution, or other financial obligations imposed as a result of a criminal conviction. So let's get started. First, we will hear from Nicole Porter. Nicole manages the Sentencing Project's state and local advocacy efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Since joining the Sentencing Project in 2009, her work has been cited in several major media outlets, and she's given countless talks on state sentencing policy, collateral consequences, and racial disparities. Nicole is the former director of the Texas ACLU Prison and Jail Accountability Project, where she monitored the conditions of confinement in state jails and prisons. Nicole, can you please tell us about the history of felony disenfranchisement and how it became law in most states?
Absolutely. Thank you so much, Jamie. I appreciate being here and joining James and Eliza, and grateful for the opportunity to share some comments with the audience today. So I'm going to share my screen and hope that this works. Is that working? People are nodding their heads. Yes, awesome. So the Sentencing Project, for folks who don't know, is a research and advocacy organization based in DC. We consider ourselves a bridge organization between the academy and the activists, and I work specifically with state advocates on issue campaigns with the goal of shifting hearts and minds on the nation's punitive sentencing laws, but also on collateral consequences like expanding the vote by ending felony disenfranchisement. So, you know, felony disenfranchisement does have a long history in the United States. As of 2020, 5.2 million Americans were prohibited from voting due to laws that disenfranchise citizens convicted of a felony offense. Felony disenfranchisement rates vary by state, and states institute a wide range of disenfranchisement policies. You know, the general narrative assumes that justice-involved residents cannot vote. This is baked into the culture. I was watching a Saturday talk show a few months ago, and that assumption is bandied about often as though it is fact, and it's not, because it's very complicated. And I know that I know that Eliza and James will share additional comments about that as well. But on the history of oh, do I need to reshare my screen? Sorry. Is that working now? It is working? Okay, great. I'll try not to complicate that any. But on the history of felony disenfranchisement, English colonialists brought the practice to North America as a common law practice before the country was actually founded. And it reinforced the idea of a civil death, a set of criminal penalties that include the revocation of rights, voting rights. And in those early colonial laws, limited enfranchisement and enforced disenfranchisement for certain offenses relating to not just voting, but also, quote, egregious violations of the moral code. After the American Revolution, states began codifying disenfranchisement provisions and expanding the penalty to all felony offenses. And many states instituted felony disenfranchisement in the wake of the Civil War. And by 1869, 29 states had enacted such laws. It's, should be no surprise to the folks in this meeting that during the post-Reconstruction period, several Southern states tailored their disenfranchisement policies in order to bar Black male citizens from voting, targeting those offenses believed to be committed most frequently by the Black population. For example, party leaders in Mississippi called for the disenfranchisement for offenses like burglary, theft, and arson, but not for robbery or murder. And the author of Alabama's disenfranchisement provision estimated that the crime of wife beating alone would disqualify 60% of the, quote, Negroes in that state's electorate, resulting in a policy that would disenfranchise a man for beating his wife, but not killing her. So today, there are more than 5 million persons ineligible to vote as of 2020. The rate of disenfranchisement mirrors mass incarceration and the experiment with mass incarceration in the United States. So you can see by this chart that as the prison system grew over the last 50 years or so, so too did the number of people disenfranchised because of a felony conviction. And as the history that I just highlighted reinforces, disenfranchisement has been used to reinforce racial caste in the United States because of the disproportionate impact that the criminal justice system has on the Black electorate in particular, and then that through line between felony conviction and sentencing to the collateral consequences that justice-involved residents experience that can be experienced through disenfranchisement and other collateral consequences. There has been a modest decrease in the number of people disenfranchised. Well, it's not so modest, although it is something to highlight, but there's still way too many people who are disenfranchised because of this experiment with mass incarceration and the punitive laws that carry through even into collateral consequences. And in the United States in particular, The disproportionate experiences of mass incarceration and collateral consequences reinforce the racial caste system that underlie this country since its beginning, and that enfranchisement policies and disenfranchisement policies help to highlight and maintain. And, I'll just bring this into sort of an international context because the United States does stand alone, particularly from other Western countries where people in prison can vote and people never lose their rights as a citizen. So there are broader issues in terms of what underlying policies of disenfranchisement mean in the United States, particularly given the nation's history around white supremacy and the racial caste system. And that's why it's so critical that we're having this conversation during Black History Month, although Black History is every day of the year, not just in the 28 days and on the 29th day every 4 years during leap year. But, it is so important to bring these conversations and to center them around, working to address them is a racial justice solution, given the racial caste system that disenfranchisement policies in particular reinforce. I'll say that there's a great deal of activism, and I know we're going to hear from James and Eliza, that has helped to expand the franchise in recent years. We document reforms dating back to the late 90s. Actually, this slide needs to be updated. Policy reforms have been enacted in about 24 states since 1997. And it's important to offer information that affirms voting rights, but also helps to support the expansion of rights that's been anchored through civil rights organizations like the NAACP, like the League of Women Voters, and expert legal activists like many of you on this call who are doing this work in your community and supporting this work as experts. An estimated 1.4 million persons have got their voting rights back since we started supporting these efforts around the country. And it's just helpful to know that in spite of the magnitude of disenfranchisement, it is possible to challenge that. And the goal of ending felony disenfranchisement will help with that. So I wanted to highlight several reforms since the late 90s. 7 states have repealed or amended their lifetime disenfranchisement policies. Obviously, Florida dominates that national imagination and that national awareness. 6 states expanded rights under community supervision for people living in the community on felony probation or parole. In fact, the majority of the 5.2 million people disenfranchised are not in prison or jail. They're actually in the community. And 17 states eased restoration processes for persons completing their sentence. So there's a lot that can be done around expanding voting rights, and I hope to get into this in the discussion and learn more about what's happening through James's work and Eliza's work. But as we wrap up the discussion on this call, there's so much work for us to be due going into the 2022 midterms, having these conversations, building out issue campaigns, and supporting the work that's happening in communities across this country. Last year, the District of Columbia expanded voting rights to people in prison, ending felony disenfranchisement for district residents. There's been credible efforts in a handful of states, and I think we're going to hear about that later during this discussion. But I know that I've already testified this year in Virginia and in Maryland because there are serious efforts in both of those states to expand the franchise and end felony disenfranchisement outright. So I'll wrap up there and look forward to James and Eliza's comments as well. And let me stop sharing my screen. How do I do that? Okay, great, thank you.
Thank you so much, Nicole. Next up is Eliza Swearenbecker. Eliza serves as a counsel in the Voting Rights and Elections Program at the Brennan Center for Justice in New York. She litigates voting rights cases, counsels lawmakers and administrators on voting legislation and policy, researches voting law trends, and comments on voting issues in a variety of media outlets. Prior to joining the Brennan Center, she was a litigation associate in private practice, and she previously served as a Ford Foundation Fellow in the ACLU's Speech, Privacy, and Technology Project, as well as a law clerk in Federal District Court in California. Eliza, can you please provide us some background on the legal cases and issues in this area and further describe the current state of the law across the country?
Absolutely, and thank you so much for having me. Thanks to the folks for joining online, and it's a pleasure to be on a panel with Nicole and James and with you, Jamie. So as Nicole laid out, the racial impacts and the negative impacts of felony disenfranchisement and the long history of felony disenfranchisement suggest that there should be a way to attack these policies in court. But despite the damaging impact of felony disenfranchisement laws, efforts to challenge them in federal court and state court have largely been unsuccessful. And the leading case on this issue is Richardson v. Ramirez, which is a Supreme Court case from 1974, where the court essentially said that the US Constitution allows felony disenfranchisement because the 14th Amendment says that states don't lose congressional representation when they deny the right to vote for someone who has participated in a crime. In other words, the Supreme Court said the 14th Amendment contemplates felony disenfranchisement and therefore doesn't prohibit it. And since Ramirez, advocates have attempted to challenge other state felony disenfranchisement policies by bringing claims under the 8th Amendment to the Constitution, which prohibits cruel and unusual punishment, and the 24th Amendment, which prohibits conditioning the right to vote on the payment of a poll tax or any other tax. But unfortunately, these efforts have largely been unsuccessful because courts have been following the precedent set by Ramirez. So for example, an Eighth Circuit decision rejected the argument that Maryland's felony disenfranchisement policy amounted to cruel and unusual punishment. Sixth Circuit decisions, Johnson v. Bredesen, said that the Tennessee's law, which required people to pay back legal financial obligations, and forgive me if I use the abbreviation LFOs at some point during this presentation, but that's what I mean, court debts, fines, fees, restitution. The Sixth Circuit said that Tennessee's requirement didn't violate the 24th Amendment, which is, as I said, bans the poll tax or any other tax that would be a condition on the right to vote. And most recently in the 11th Circuit, in a case that we at the Brennan Center litigated along with other partners, the 11th Circuit rejected 14th Amendment claims as to wealth discrimination related to related to Florida's condition that people pay back their fines, fees, and costs in order to get their rights restored. Another 14th Amendment claim that we brought to demonstrate that people don't even know what they owe and therefore their due process was violated. And a 24th Amendment claim arguing that the right to vote can't be conditioned on the repayment of certain fines and costs. We actually won in the district court after several days of Zoom trial, but the 11th Circuit overturned that decision. Courts have also held that Section 2 of the Voting Rights Act, which prohibits states from denying the right to vote based on race, doesn't apply to felony disenfranchisement laws. Others have held that proof of intentional discrimination is necessary to challenge these laws under Section 2 of the Voting Rights Act. And challenges under state constitutions have fared similarly poorly. For example, in last year, just in 2020, a Minnesota court dismissed a lawsuit challenging that state's policy of disenfranchising people on probation because the plaintiffs, according to the court, had failed to show that people convicted of crimes have a fundamental right to vote. There was a victory in North Carolina last year, though, which struck down a portion of the state's law that blocked people from voting because they still owe court debt. And I should note that these state challenges are being brought under the state constitution. So it doesn't present the same Richardson v. Ramirez problem that we have found in other federal courts. In terms of the sort of state of felony disenfranchisement laws across the country, I'm going to refer to a map if I can bring it up. Let's see if I can manage. Did folks see that map? I'll look for nods. Okay. And can you see my crib sheet at the same time, or just the map? Okay, we'll just take it from here. But as you can see on the map, the scope of felony disenfranchisement laws varies quite widely across the country. The states that are in dark blue, Vermont, Maine, and Washington, D.C., don't ever take away the right to vote. states that are, and as Nicole mentioned, DC is new to that list as of last year. The states in light blue let everyone in the community vote. And again, we've had significant movement toward that policy among states in recent years, including California by ballot initiative last year, which was a huge success. And then the remaining states have sort of a mishmash of policies that fall somewhere in between. Many states prohibit people from voting while they're on probation or parole. Others impose waiting periods or require payment of court debt. Some permanently disenfranchise people who are convicted of certain offenses unless they receive a pardon from the governor. But as Nicole mentioned, there have been major successes over the last several years. Last year, the two remaining states, or I should say over the last 18 months or so, the two remaining states that had permanent policies of categorical disenfranchisement, Kentucky and Iowa, both changed their policies via executive order. So we got to get rid of one color on our map, and we were very pleased with that. Although, as Nicole also mentioned, there's a lot of work to be done with more than 5 million people who are disenfranchised, and most of those people who are living in the community. So I will leave it there for now and see if I can unshare my screen. Thanks.
Those insights and your work. Now we will hear from James Jetter. James is co-director of the Full Citizens Coalition to Unlock the Vote and founder of the Civic Allyship Program at Dwight Hall at Yale. James is a leader on voting rights restoration in Connecticut and beyond, and is also dedicated to the cause of prison education and has sought opportunities to apply his own knowledge and experience to benefit those still incarcerated or returning home. James, welcome, and can you please tell us about your work to organize community and change the law in Connecticut?
All right, thank you. And thank you for the introduction, because I'm not good at bios. My bio for her was like one line. She just like extended it. My name is James Jetter, and I've been the co-director of the Full Citizens Coalition to Unlock the Vote for 3 years now. The Full Citizens Coalition to Unlock the Vote is a voting rights coalition that is seeking to abolish felony parole, disenfranchisement in the state of Connecticut. I think what this work has shown me is what it has reinforced and shown me is how intricate and detailed and intertwined racist narratives are in our psyche, and how they affect our entire population, not just those who are disenfranchised, but their entire community and the communities that oppose enfranchisement. The lack of rights it leaves you in a state of non-citizenship. Like, we don't have much in this country like that is solid as a citizen. You have rights, that's it. You have, it's life, liberty, and the pursuit of happiness. You can pursue it, you may never catch it, but these are things you have, and life and liberty are tied into your say, and the only say you get is your vote. It's your stake in this place. And as Nicole broke down how we come to this place, where we bring this colonial thought process into the forming experiment that creates a nation. We also have to acknowledge that I think, which is super important around this issue, is how we define criminality and where it comes from. And so when she points out that, you can disenfranchise 60% of Black men in Alabama by making wife beating a felony offense that does disenfranchise, this is the structure of what crime, not that that's not a crime. I'm not saying that. I'm saying that, the focal point on what designate degrees of offense and the atrocity of offenses where killing your wife somehow doesn't disenfranchise you at all, forms in our nation. And so, you have the 13th, 14th, 15th Amendment, and the 15th Amendment to me is like the sham amendment that, it sanitizes what's already been laid through the 13th and the 14th. Our entire penal code comes out of the 13th Amendment. It is our legal definition of slavery. It's not so. Mass incarceration is mass carceral slavery, and when you've established that, then it's easy to create a 14th Amendment that can lock people out, and then say you all have the right to vote because you've already done the damage through previous legislation. So undoing it on a state's level is super hard, because you're dealing with populations that have been disenfranchised one way or the other since their emancipation into the structure of our country. And so you often you go to do community work and you get intergenerational hurdles where no one votes in families for 3 to 4 generations. And it becomes the hardest conversation to have because you're talking about 3 to 4 generations also of poverty. And so, to sit in front of people and tell them about how they have to get active. And I myself wrestle with the fact that I'm 40 and I've lived through 5 presidents, and, the level of poverty in my community hasn't changed. Things haven't gotten better. Yet I wholly believe in, having my rights. So I'm fighting because I too am on parole until I'm 52. So I'm fighting for my own rights. But it's a hard argument when organizing around it, because the lack of participation is intergenerational, and it's stood on because people can't see a difference, no matter who's at the helm. They fail to see the improvements that they're being told that voting brings, and yet, come any gubernatorial and presidential election, there's a lot of money and there's a lot of people who are walking around telling you have to get out and vote, you have to get out and vote, you have to get out and vote. We don't take that stance. We lay out the history of disenfranchisement, and we're explaining to our communities that we don't know if this works. We don't. We've never had it to say that this works. But we do realize that the only way to understand or see if it fully works is to have full participation. The way that the loss of rights affects the common life of people in my community is that as long as you don't have your rights, then you don't have a say in how everyday structures are being formed. So a lot of men and women who return from prison, the skill sets that they have, they're not allowed to get certified around. And these are simple laws that can be changed, but the hurdle is that they're not involved in saying that it's a hurdle. And so no one's looking to change these laws. Simple things as far as getting licensed to be a barber. It's the one skill that I know a lot of men can come home with, but they can't get licensed if they have violent felonies on their records. It's not that it's illegal, it's that the licensing board, which is structured in a funny way, won't license them. And so, we discovered that while doing a barbershop tour. We've had 2 sessions where we had bipartisan support behind our bills. And we had a new governor who came in and said that our bill was one of his primary one of his primary goals to happen in his first year. At the end of that session, nothing happened. These are back-to-back sessions of nothing happening with all the support. And I remember me and my coworker, we were walking back to his apartment from the Capitol, and he just stopped and was like, I can't get mad. This is 400 years old. We didn't change it in 2 years. Like, it's a fight. And the following session, we started working with Eliza and the Brennan Center, and we changed our entire approach to be far more community focused and far less on the political advocacy side. And that became such a great shift to help us navigate and find out how do we build a true power base in our community. And we're still in the mix of trying to figure out what that looks like, because in the major cities in Connecticut, you don't win a local election by a vote, you win it by the lack of participation. And so you can, in a city of 100,000, you can become governor with 5,000. I mean, you become mayor with 5,000 votes. You can become a city councilman with 1,000 votes. You can become a state legislator with 3,500 votes. So people aren't voting. And though, you have all the registration drives that take place every other year, you don't have the turnout or the education. So these become the most important aspects. And what also has become important is figuring out who actually votes. So, this year we're looking to build a community college coalition and expand it up to the state colleges, because the one place where voting is like strongly supported and pushed and campaigned is college campuses. And our community colleges are our community. They are, when people return from prison, it's if they go into higher ed, that is usually their gateway into higher ed. And I have a niece who went through that through the community colleges to a state school, and her father did time in the feds. I did time in the state, and so like I understand that there's huge impacted populations right there who are willing to vote. And so what we want to do is organize uh, those who are voting from our communities to actually stake their vote behind the issue, to create a community platform that says that this is what we will vote. These are the lines we're drawing. This is what we will vote you in and out of office on. I love the thought of working with this particular population, because they'll be voting for the next half a century. And I think that's the power that is needed to push legislation, because a lot of lip service. And then there's also, the narrative of crime and punishment is so ingrained, not just into our nation, but into Black skin. Like it's so hard to remove the criminality that so many believe is inherent to just, being kissed by the sun. So undoing that work takes so much more to shift the culture of it, like in our own communities, let alone the suburbs and rural parts. My state is small, but it's 75% rural, and it has a very liberal tag, but it's a very unliberal state. And how voting works isn't something that has been structured in the minds of any of our citizens, because when advocating at the Capitol, we would hear things from others advocating on others' issues, like, well, what if all the pedophiles vote? And I'm like, okay, like our government isn't set up that, one population can dictate of it is, however, but it's not set up for that one population to dictate a vote or to eradicate law. There's so many balances that's not a real thing. And so you get the fear of the unrealistic that drives so many more parts of our communities that we have to find ways to combat now. So I'm gonna stop there.
Thank you so much, James. There's so much to learn there, and that we need to, and the building that power in all of our states. And I feel that frustration of working through a couple sessions and being so hopeful that we're gonna get the bill passed, and then sadly the politics kill it. So in my state, we also have similar legislation that we're really hoping to get through this year, and we're going to keep fighting and pushing. Well, thank you all so much for those comments, and I want to open things up with a few questions, and please feel free, any of you. These are just questions generally for the panel. Let's start with again, this issue is important for so many reasons and on so many levels. But if you might reflect on, I know all of you work with impacted people who are not able to vote due to these felony disenfranchisement laws. And in your experience, tell us why this issue is so important for the people that you work with and what restoration would mean to them. And if you'd like to reflect on why voting rights restoration is good policy and what the studies tell us about reentry and civic engagement and recidivism.
Well, I'm happy to jump in here. And I can say, working with impacted communities, one of the things that I hear a lot is that restoring the right to vote would bring people back into full citizenship. And that they're really, and I think perhaps I heard this most beautifully said by James, which is that there really is no citizenship without the right to vote. So I think that's, hugely meaningful to folks who have been denied the right to vote or whose vote has been taken from them. And I'll certainly let James speak to that more because he can speak from his own experience. But just to your question, Jamie, about policy, what we have learned from the handful of studies out there is that civic engagement actually reduces the risk of reoffending, rearrest, and return to prison. And research also indicates that restoring voting rights leads folks with past convictions to develop stronger trust and cooperation with the police and the criminal justice system. And in fact, we see support from many law enforcement officials and criminal justice professionals, including the American Probation and Parole Association. Here in New York, where we're fighting for a rights restoration bill, 7 DAs have supported that policy. So criminal justice professionals understand that voting rights restoration is good for whatever state it's being advanced in. It's good for the society. It's good for those who are returning citizens. It's good for everybody's communities to welcome folks back, welcome them with open arms, welcome them as full citizens. And that it's part of, reforming our criminal justice system is to not continue that punishment indefinitely in many cases, but to say sort of like the punishment or the debt to society is over, and welcome people back into the community.
I'm very strategic, idealistic, and naive all at the same time. So, and extremely skeptic and borderline pessimist. And and I'm comfortable with being all those things. I live in a country where, coming home from everyone I know in prison is seeking redemption, right? And I had to wake up one day and be like, I've never been deemed anything. Why am I seeking redemption? And I'm not a liberal. I'm not a conservative. I'm a Black man in America. I don't have those lanes. I've had as much harm done by liberals as conservatives. It's hard for me to call conservatives my enemy. I don't know any. But I know liberals who have slapped me in my face several times over, not physically, but like just in the lies that they've upheld, the bills that they've denied, the way that they've moved. And I still yet believe that citizenship is something that I can actualize, that I can have, and my community can build a power base that doesn't, place them in a place to oppress, just a place of equality with some equity to where they're no longer oppressed systemically through things that have been toppled upon them for centuries. Yet I'm not convinced it works either. I'm hopeful that we can come to a place to really actualize the experiment. Voting, but the only way to get there is to really restore those who are the most oppressed in your community. The way voting works in households, at least in my experience, is that if the parents don't vote, the children won't vote. And so you get this cycle that just doesn't break. The one thing about people coming home, like I said, is that they seek redemption. They seek redemption for better or worse. They want to prove that they have value. And part of that, and what that does, it gears them to be right, to be active civically, which empowers them to believe in themselves. So this type of in engagement, gives someone stake. How real it is, how effective it is, we haven't seen it. I wholeheartedly believe that given the right to vote, we can change our local governments in a way that make our cities operate in a way that is beneficial to everyone and not just to one particular neighborhood and or suburban offshoot of the city. I hear from guys who and women who I know have come home and who are still incarcerated, and they can't wrap their minds around voting in prison. Right? They can't wrap their minds around having a say while incarcerated. And it's mind blowing. And it's mind blowing to me because I can finally see it. And it's mind blowing to me because when I was incarcerated, neither could I. Right? It took me coming home and doing policy work and seeing how voiceless I am in the Capitol. Sitting there and I came home very fortunate to a very low paying policy job. But it was a job that gave me the breath to just the space to do research and to imagine how things could change. And, it was around housing and underbanking in Connecticut, but I would have to go to the Capitol and sit through, these public hearings that were just, atrocious around these issues. And, I realized there's so much going on that we have no knowledge of, so much that makes no sense. And it's no one's fault, because who has time to go sit in the Capitol and listen to a public hearing when you're working and you have kids and you have this isn't a thing. So it dawned on me how much we're locked out of and how much we don't know we're locked out of. We just accept certain things. So it's hard to pinpoint the effects on the community that doesn't know what's happening. It's very hard, but I still believe that it's the only way to move anything forward.
Thank you both so much. So let's talk strategy a little bit. We have been this whole time, but if you have any additional reflections on what are some of the legal and policy strategies that are being used right now. We're hearing about some progress in a few states to restore voting rights. And what are some of the common political challenges and barriers to advancing this legislation?
I think they're sort of touched on in states where there's credible efforts, there's an interest to carve people out of the solution or of the change, because I think sometimes the advocates start from a place that it'll be more politically possible if we just, say that certain people, because of certain offenses, can't vote. I think when people start there, they forget that the sentence in and of itself is the punishment, and the collateral consequence of voting and any other loss of civil and human rights should not be extended to that punishment. And that there is work for advocates to do. So for people who are working to expand rights and not compromising from the beginning. I think I saw in the chat a question around what is some of the main opposition to this, and there are a lot of assumptions that get thrown around with the pretext of limiting the vote with the goal of maintaining the status quo. And I think outside of our efforts to expand the franchise, there is a through line through American history where people who oppose expanding rights to justice involved residents just do not believe that there should be a broad electorate of fully enfranchised citizens in this country, regardless of experiences, whether or not that's about expanding racial groups' interest in the franchise to justice involved residents and other minority groups into the franchise as well. In that pretext, the goal of limiting the franchise people will use that pretext to restrict rights, and the current sort of reinforcement of loss of rights is very acutely obviously experienced by folks with the felony conviction history. And so working to address that and not be convinced that it is legitimate to disenfranchise any citizen, given the pretext of narrowing the electorate, is work for voting rights advocates and racial justice advocates to be centering in this fight and in this work.
I'm happy to jump in, Jamie, or if you want to move on, that's great as well. Just let me know.
Go ahead, or James too. Look like you both unmuted.
Sorry, James. I was just going to say, there are all kinds of ways that the fight for rights restoration is sort of playing out across the country. As James described, there's grassroots advocacy and organizing that is happening, and I think part of that is storytelling. So rights restoration is actually enormously popular, like across the political spectrum. That's why you got Amendment 4 in Florida, because people across the political spectrum overwhelmingly supported it, and they get the idea of second chances. What we need to do as advocates is just communicate how important that is and prioritize it, both among voters, but also legislators. So hearing individual stories, understanding the impact on people's lives, that's super important to that sort of both the grassroots organizing and advocacy, and also the lobbying of lawmakers. So they get that this is not sort of a 50,000 foot policy, but this is a policy that affects people's lives, and it affects households. It doesn't just affect the individual person who's disenfranchised, and surely it does, but there are spillover effects. So research from one of my colleagues at the Brennan Center shows that turnout rates are lower in communities and neighborhoods where there are more people disenfranchised. So as James suggested, his experience talking to folks, his anecdotal evidence is backed up by the numbers too, that this affects entire communities, not just the individual people who are disenfranchised. And then even though I started off talking today about the sort of mixed results from litigation is a way that we can change the policy and also the environment around this issue. Even though the decision in the 11th Circuit ultimately didn't go our way, I think we actually achieved a lot by litigating that case in Florida. Over the course of the litigation, the state's clemency rules changed. The state changed its voter registration form to be clearer for people who could register and who couldn't based on that form. And I think we educated the country about a felony disenfranchisement policy that was effectively a poll tax, and to let people know that this is, poll taxes are not a thing of the past. People are still having to pay to get their right to vote back. And even though the 11th Circuit didn't seem to find a problem with it, I think nationally folks understand that's not okay. And so we can tell stories through litigation. Hopefully we win, but even when we don't win everything we'd like to win, we can still sort of start to notch some victories and change minds.
As far as I was saying this the other day, and Elijah summed it up the best. She's, build power, use power. It drives me insane. Incrementalism is like a slow poison that conservatives don't use. They get done what they want done, and then we get Democrat representation who incrementally try to install things, and I think that's where we lose constantly. We have to build stronger power bases that actually cast votes and to create our own platforms on what will support who gets our vote instead of backing a candidate. We're facing too much. That's what I appreciate it in a weird way. The insurrection at the Capitol. I think it brought clarity to what we're facing. We're facing something that isn't new. We're facing something that is historic, that it's intertwined into the minds of what this nation was meant to be and currently is. And I don't necessarily know how you undo that. I just know what we're up against. Yeah, and I don't, because you can't ignore our courts. Eliza lays out all of the hurdles and all of the denials, but our courts have been historically racist. Like we have to just, I think, as a good strategy, just to start admitting and owning some stuff about where we were and how we're still there. Especially when it comes to our courts. We can go back and look at rulings straight through. Well, I don't think they've never stopped. We have, so you can go back and consistently see rulings that have been based solely on the ideology, the culture, codified culture of who Black people are. And Black being the base of the spectrum. From there it goes up, it gets brown. But, we have to be willing to have a reckoning with that. And then, be willing to move forward. And there's a lot of unwillingness to move out of that.
Thank you. Thank you all. Kathleen, do we have, I see a couple questions in the Q&A from the audience.
Yeah, absolutely.
I think we have time for at least two.
Okay. So one of the questions is asking the panelists to discuss the connection between felony disenfranchisement and the loss of other rights due to felony convictions, such as the right to serve on a jury.
You can't serve on the jury unless you can vote. Just that simple. You got to be a registered voter. You don't have that right.
And another question is, can you discuss the interplay of various structural racism policies with felony disenfranchisement laws?
I don't think we got enough time for that. I think we touched on it already too. So invite the questioner to maybe review some of what was shared earlier, but there is a cumulative disadvantage that defendants of color experience that start with arrest through post-sentence experiences like the loss of voting rights. And so that through line of racial disproportionality and why people get caught up to begin with, and then the punitiveness that underlies the system, which I hope was clear in my earlier comments, is a part of that issue. And it can help tease out the interplay between structural racism and felony disenfranchisement.
Thank you. And we have a question from one of the participants about how would you respond to legislators or others who claim that voting rights restoration is somehow disrespectful to victims of crimes, especially serious crimes like rape or murder? And a similar question, what are the justifications for felony disenfranchisement, and how would you respond to that or rebut that?
So I actually had to answer that question. I was testifying last session, and someone said, I find this wholly disrespectful to the victims of crimes, and even the simple answer that I can give them is that I can't think of anything more important to a crime victim, someone who's been victimized, than to assure that the person who caused them harm is no longer out here causing more harm. It's been proven that when someone is civically engaged, when they're active, it reduces the chances of them recidivating, going back to prison, or creating other harm. They now have a stake. Like it's a sure way, a sure pathway of knowing that someone is working on themselves, which I don't know if there's anything more that a victim can want.
I think I would also just add that, you know, for all of the flaws in the criminal justice system, and I think there are many that those of us on the panel could agree on, the criminal justice system issues a penalty that, you know, it makes an adjudication as to how much people should be punished. And we can leave that judgment to the criminal justice system. We don't need to heap on additional punishment, even beyond that, onto people for many, many years. And as James said, the most pro-social thing you can do is go out and cast a vote and, you know, cast your lot in with your fellow citizens and say, like, I too want to make this community, this state, this country better. I'm looking out for my family and your family, and we're looking out for each other. And so the casting a vote is a way of taking care of one another and not sort of any sort of disparagement or any harm to somebody who may already be a victim.
There's a bigger issue too. I mean, practically this would never happen, but the possibility is there that the way felony disenfranchisement operates now, given mass incarceration, is it mediates. The criminal justice system is a mediator between the citizen and those who govern the electorate. And if possible, if practical, you know, you could imagine in an autocratic society, and we just sort of survived, at least in the short term, not moving into a complete autocracy, that law enforcement in the system could be used indiscriminately to take away people's rights by just arresting them and disappearing them into jails for a short period of time, just around election time. Mm-hmm. And we have a carceral system, given the large number of prison beds and jail beds, that could make that possible. So, you know, that's, you know, assumptions around the, you know, or looking at a possible dystopian community, and we don't want to get into, you know, conspiracy theories, but I'm just saying that the criminal justice system, given the underlying structure around disenfranchisement, is currently a mediator between the electorate and those who govern us. And doing that can help prevent the worst possible outcome in how the criminal justice system can be used to limit and restrict rights for all citizens.
Thank you so much. And I think as a closing question, the attendees have asked if you could tell them about specific opportunities for lawyers to be involved in how to support changing this and reducing or eliminating altogether felony disenfranchisement. What can they do?
So I think lawyers and non-lawyers can call your state reps. In Washington State, for example, where Jamie is, in Connecticut, where James is, there are bills to restore voting rights that are before the legislature now. Call your state reps and tell them you want them to pass those bills. Even if you think that they support them, it's important to know that their constituents, their electorate, is energized around these policies. Call your federal representatives, your members of Congress and your senators, because the John Lewis Voting Rights Act and the For the People Act are going to be or are already before Congress this session, and that will make a huge difference nationally, including the fact that the For the People Act includes the Democracy Restoration Act, which would restore voting rights to everyone living in the community for federal elections. So those are things that any person can do, regardless of whether you're a lawyer or not. And I know, James, you talked about how sometimes boring those legislative hearings can be, but anybody can go and show up and try to testify before your legislature. If you have something to say, if you have a story to tell, when there are hearings on these bills to restore voting rights, you can, you know, now you can do it, I think, from home in most cases because of Zoom, testify and tell your legislators face to face that you want to see rights restoration pass in your state. So that's you know, my pitch.
I got one. So it's kind of out there, right? But this is what I would love to see. I would love to see lawyers help draft up a class action lawsuit to have those who are disenfranchised exempt from paying taxes. Fundamentally, our country, we committed terrorist acts on taxation without representation, and yet we've designated millions to that same reality. So I would love to see a lawyer do some research and draft up a class action that we can all get behind, because they can keep my vote if I don't got to pay this country's taxes no more.
Great. Well, thank you all so much for joining today's webinar. We'd also, we really want to express our gratitude to this amazing panel. And you all are doing such critical work, and we thank you for taking the time to share your experiences and expertise. This section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, please consider joining and becoming active in the ABA and the Civil Rights section. You can find information on and other free programs on the webpage. And on a personal note, as I mentioned, I'm very hopeful that my state of Washington will pass the bill currently pending in our legislature to restore the right to vote to all citizens no longer incarcerated. And by passing this bill in 2021, we'll become the 21st state. So the time is now to strengthen our democracy and dismantle the racist legacy of felony disenfranchisement. Our democracy is strongest and most equitable when every voice is heard. So thank you again to our panelists and all of you. Please stay safe and best of luck.